So welcome, this is CPA question 5, not question 5, question 4. It's question 4, CPA April 2022. Introduction to Law and Governance. So question 4A, discuss 5 potential disadvantages of litigation over alternative forms of dispute resolution. 5 potential disadvantages of litigation over alternative forms of dispute resolution. Now, litigation is going the court way. So this is where you open legal proceedings you go through the legal proceedings through the courts of law. Now, the courts of law here, we are talking about the whole of that hierarchy. We talk of the magistrate courts, the high court, the court of appeal, like that, the Supreme Court. All those will come under the litigation. So if you filed a legal suit in any of these courts, then we are talking of litigation. That is the litigation way. Other forms of dispute resolution include arbitration, mediation, conciliation. So we are talking about the examiner is interested in the disadvantages of litigation over all these other forms of dispute resolution. Okay, so let's look at the disadvantages that come with litigation, that is going through the court way. Number 1 is that most of the courts have a backlog. Most of the courts have a backlog of cases going all the way back to 20 years back, 10 years back, 30 years back. So most of the courts will have backlog of cases, and because of this backlog of cases, it will basically take a longer time to handle any one case to completion. So the first disadvantage that is very obvious is that the court process is likely to be lengthy as compared to these other forms of dispute resolution. Likely to be lengthy, 1, because there are so many other legal suits and there is a backlog. Mostly the courts will have a backlog. This is a phenomenon that is found almost in every country. Then we have the whole process of litigation process is costly. It involves the legal practitioners. These are the advocates who present either the plaintiff, the defendant, so, and these people are very expensive. So they will always require a good sum of money as compensation for their services. That makes the whole process costly. So it's very costly compared to these other forms of dispute resolutions, which might not necessarily require the advocates. And even if they do, because the process is quite shortened, it makes it at least becomes a relief in terms of the costs involved. Then we also talk of one of the other disadvantages that parties don't have a say. Parties may not be involved, in decision making on who should possibly run over their case. So they are not involved in the selection of the judge or magistrate. And like in arbitration, the parties are involved in selecting the arbitrator. In the litigation, parties are not involved in the selection of judges or magistrate, and so you are at the whoever will appear, that is the person that are going to present your case to. And of course, there's also another disadvantage that comes with that, that sometimes some of these the judges might not really be so much well informed in the subject matter of the case, and so you might not get a quality judgment, as opposed to if we are talking about these other forms like arbitration, where it's highly expected that you're going to pick an arbitrator who has a very good grasp and understanding of the subject matter in question. Then for the other disadvantage is that the direction of litigation doesn't allow creativity. It doesn't allow creativity in the judgment. And this is an advantage that is possibly going to be enjoyed when you go the dispute resolution way, where the arbitrators might go out of their way and apply creativity. In the litigation direction, the law has to be applied to the later. So there's no room for creativity. There's no room for the judge to go outside and try to bring in the real social experience. It might not really feature. Instead, he will go with the arguments that will be presented to him or her, though they may not be practical in real life. So that basically appears as a disadvantage to the litigation process, because creativity is hindered, and the judges are forced to be rigid to what the law says. Then the other disadvantage is that it might leave you with an adversarial kind of a relationship. Basically, it might even damage the relationship that is already damaged. So it leaves around an adversarial kind of a relationship, because the judgment might not really be for bonding case, but for it's about the damages, the fairness, justice, but the bonding aspect may not really be captured by the courts. They might not go to that extent. So in most of the cases, yes, the parties will get the justice. One party is likely to be happy for getting justice. The other party might not be happy, and at the end of the day, it creates an enmity kind of a relationship between the two parties. You can think of, if you're talking about an employer-employee kind of a relationship, husband-wife kind of a relationship, you talk about neighbors, and the judgment has come in, in favor of one and against the other, without really going into detail of trying to bring these people back again together. So it can easily be a platform for creating this damaged relationship, or furthering the already damaged relationship. Sometimes the other disadvantage is that the court proceedings may be public. And because of public, it might have a negative reputation to the parties involved, as opposed to the alternative forms of dispute resolution, which some might be private, held under in closed doors, and so the award or whatever happens there might not be open to public scrutiny, which goes or comes in as an advantage to the whole process. So I think those are almost, these are 1, 2, 3, 4, 5, 6, 7. These are 7 points. Yeah, you can get any 5 from these, and then you will be good to go. This should be able to satisfy the examiner on this question. Let's look at the second part of this question. Describe 5 ways in which an offer might be terminated. Now, an offer, this is a question from the law of contracts. We have offer, acceptance, all those things, the procedures for or elements for entering into a contract. We have The parties to an offer will have the offerer, and we also have the offeree. So we have the offer, and then we have the offeree. The offerer is the party who makes the offer. Offerer is the party who makes the offer. Party who makes the offer. And then offeree is the party who accepts, who either accepts or rejects the offer. Who accepts or rejects the offer. The one who is being sold to. So the party who makes the offer is the offerer. The party who is supposed to either accept or reject the offer is called the offeree. Now the question is 5 ways in which an offer might be terminated. Number 1, revocation of the offer by the offerer. The one who makes the offer revokes the offer. So that means that the offer will be non-existent. But he has to revoke the offer before the offeree accepts it. If he revokes the offer after the offeree has already accepted, then it means it has moved to the next level of the contract. But if he revokes before the offeree accepts, then that will serve the purpose of terminating that particular offer. If he revokes before the offeree accepts. So this is one of the ways that an offer might be terminated. Revocation of the offer by the offerer. The one who has put forward the offer basically takes it back before the other party, who is the offeree, accepts. In such like a case, that offer will have been terminated. And then we have the other way of terminating an offer is a counter offer by the offeree. A counter offer by the offeree. This has the effect of terminating the original offer. Terminating the original offer that had been put forward by the offerer. So there's an offer that was put forward by the offerer, and then the offeree comes in with a different offer. The different offer will have the effect of terminating the offer that was put forward by the offerer. For example, Party A approaches Party B and tells Party B that he is selling a certain item at 1,000. Then Party B proposes a figure of 1,200. So this offer has already been terminated. This is the counter offer. If Party B or the offeree brings in a different offer or a different figure, then the first figure automatically gets terminated. That's what we mean by a counter offer by the offeree. Then number 3 is rejection of the offer. Rejection of the offer. Rejection of the offer by the offeree. And this is where the offeree just doesn't feel that that is a good offer to take, so he rejects it. To reject is basically to refuse. I'm not taking that offer at the terms and conditions that are prevailing. So that one is just the outright rejection or refusal to take over, to accept to that particular offer that has been presented to you by the offerer. That will have the effect of terminating that particular offer. Then you also have lapse of time. And this is very common, especially when the offerer gives a time frame that if you don't hear from us by this date, then you consider the offer terminated. So if indeed you don't hear from them, then that remains the position that the offer will have been terminated. If time has not been expressly indicated, then the court will go with what is considered reasonable time. So if the reasonable time for the offer to remain valid is still in force, then it means that it is still valid. But if the reasonable time has already lapsed, then it means that that offer was terminated by the lapse of that time. So very common, especially when the offerer gives a time frame that we will communicate by this date. If you don't hear from us by this date, then it means that the contract will have been terminated. So time, yes. Then we have death. Death, and this death can be death of either party, death of the offerer, or death of the offeree. Of course, if there is death of the offerer or the offeree, and this is the person who entered into the contract, especially if it's a service or then automatically that means that the offer is terminated. So death or disability, you can talk of permanent disability of this person who is supposed to offer the services, or who is supposed to, either the offerer or the offeree, can also end up terminating the contract. If the subject matter is declared illegal, that's also one of the reasons why a contract, why an offer could be terminated, because we cannot go ahead and practice and do what is illegal. So if it's illegal, it means that the offer automatically becomes terminated. Then we also have this one, the qualified or conditional. A qualified or conditional acceptance by offeree. This one will also have, he has accepted, yes, but it comes in with some conditions. So these conditions will serve the purpose of terminating the original contract, which didn't have the said conditions. So if we accept on an offer with conditions, then that offer with conditions will now surface, and the previous offer which didn't have the conditions will have been automatically terminated. So these are around 7 points, and the examiner is only interested in 5. So you can pick any 5 from this and you'll be good to go. Thank you. Let's meet in the next question.